We'd like to welcome you and call to order the June 25th Code Enforcement and Nuisance Board meeting. Madam Clerk, could we have a roll call, please?
Ullman.
Here.
Gonzalez.
Here.
Harmon.
Here.
LaPointe.
Here.
Okay, at this point, have we reviewed the minutes, and can we get a motion?
Motion.
I'll second it.
LaPointe, Harmon, roll call, please.
Ullman.
Yes?
Gonzalez.
Yes.
Harmon.
Yes.
LaPointe.
Yes.
At this point, we'd like to swear in the staff. Please rise. Do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God? Yes, sir. Thank you. Madam Clerk?
Agenda item 2024-27 is an appeal for planning and zoning, case number 2024-4907 for citation number 2024-7989 with a citation fine in an amount of $600 for the property located at 1208 Beauty Avenue. The owner of the property is Taylor Cook Property Leasing Group, LLC. Respondent Matt Cook or Caleb Miles. Are you? Okay, they are present. So they will be able to address the board. James Hetty is not available to present the case, so Rachel Hurt will present for him.
Thank you. And so this is in reference to the property at 1208 Beauty Avenue, and we'll just run through kind of a brief property summary with a few photos. You can see this was the street view from May of 2022, where the property was still residential in use. If you look at the next slide, the initial complaint came in August of 2023 that gravel had been added to the property. And so you can see it's kind of starting to transition in this photo where that gravel had been added. If you go to the next slide, you'll see an aerial comparison. The year 2023 on the left-hand side, and then the 2024 aerial is on the right-hand side. We had received another complaint in January of this year that a towing service was operating from the property, and so you can see some of those vehicles that are located to the rear of the property in the 2024 aerial view. And then on the next slide, looking at the case summary, you'll see that the case has been open for 320 days, and the first notice of violation was issued in February. The first citation was then issued in May of this year, and then here we are this evening to consider the appeal of the citation. I'll be happy to answer any questions.
Could you summarize for us what they need to do to come into compliance?
Sure, yeah. So there has been some movement towards compliance since the original notice of violation was issued. The tree debris has been removed from the property. They have removed, there was previously gravel in the front yard. That has been removed, and a majority of the vehicles have also been removed. At this point, to come into compliance, they would have a couple of different options. The property, as I understand, is for sale, so it seems like they're trying to just vacate the property. They may be able to speak more to that in just a minute. But at this point, we would be looking for all of the gravel to be removed, the vehicles to be removed, any signage associated with the towing business to be removed, and then there are some fence panels that are also not related to the towing operations that would also need to be removed to come into compliance. The other option would be to go through site work permit approval and review to actually bring the property into compliance for the use if they wanted to continue operating the towing business, but it seems that that may not be their plan at this time since the property is for sale.
Any other questions? Thank you. Would the respondent step to the podium, please? Will you state your name, please?
Caleb Miles.
Caleb?
Caleb, could you please move the microphone down, please?
Caleb Miles.
Matthew Cook.
Thank you. If you could raise your right hand and let me swear you in. Do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
Okay, thank you. Go ahead.
Okay, so as Rachel had stated, we were using this property as an impound lot. The the property was purchased at the master commissioner sale. Whenever we noticed that prior to purchasing this property, we were leasing another property on Beauty Avenue, 855 Beauty Avenue, to be exact. We had leased that property since the start of our business, and whenever we saw this property come up for sale, I did some research. From what I could find, it was zoned light industrial. So to my knowledge, it was zoned correctly for the type of operation that would go on at that property. So light industrial, you can have towing operations, you just can't have wrecked vehicles, which is required of the heavy industrial zoning. So as Rachel had stated, that she said that the property was zoned residential. When was that classification made?
Just to confirm, the zoning of the property is industrial, but the prior land use that existed was residential, single family.
And the current land use is vacant, is that correct?
The current use would just be industrial because you had been operating the towing business.
Okay.
And you're correct that that type of business is allowed in light industrial. It's just that there are certain specific use standards. I think one of the main things in this case was the screening, and the gravel area was what was in question, not necessarily the use itself.
Okay. And so regarding the screening, we did apply for the fence permit. That was applied for back in July of 2023 and issued back in August. So when that was applied for, we applied for a commercial fence permit and it was approved. So it was brought to our attention that we would have to apply for another fence permit that is specific to industrial use, which does have the screening requirement. So, that was our error originally, that we applied and sought for and were approved the incorrect fence permit, which doesn't have the screening requirement. That, wasn't caught until they did their inspection on the property. But, and that's when, we were made aware that we had the wrong fence permit. And so in regards to that, there are two violations regarding the fence. It's I believe it's violation 4 and violation 6 that talks about the screening, that outdoor storage and vehicle towing storage has to be screened. So those two are very similar, we feel. And then also the violation for 1 and violation 2, talking about that a site work permit and the site development plan is required. Again, we didn't think these were required because of the current zoning being light industrial. It's just that the previous land use, when it was a home, was residential. Whenever we bought the property, like I said, at master commissioner sale, we paid $26,000 for it. And, most of that money went to the city to recoup all of the property taxes. There were multiple code enforcement violations due to the status of the home, the status of the yard. That was paid off with the sale. So to get, I guess, where I'm going with this, it's just a, I guess, lack of the proper knowledge of the zoning of the property when we initially sought to purchase the property and make it used for a towing and storage use. So, yeah.
And there's a many of lots that don't have screening, that's never had screening, that does impounds or tow and storage, and they've never had screening. We've been in business for over 3 years now, and we've never had screening. But, and we don't even have wrecked cars. We have cars that they come and get the next day or the next hour, private property impound. Also, I want to add that the house, we had talked to the city about tearing it down. We actually applied for a demo permit. We canceled it when we found out that we couldn't rebuild it back. So we never had intentions of rebuilding back residential, but we were going to turn it into a garage. But we thought it would cost more money to rebuild that into a garage than it would be to actually build a garage from scratch. So we canceled that. Yeah, that's all for now.
And also to piggyback on what he was talking about, the structure that's there. So we did apply and receive approval to install a garage door on the rear of the property as well. But like Rachel had stated, this property is listed for sale. We have decided to put it up for sale and take the property back to its original condition whenever the property was first purchased. We're going to remove the fence entirely, not apply for a new permit to get it screened, and also remove the gravel. As you could see from the picture that she showed, there was already existing gravel there, and so with that gravel already being there, we thought that it would be grandfathered in. We didn't know that if you add new gravel or existing, or add gravel, that just completely wipes that out, because there's the gravel parking lots over at the medical center. They don't have to be paved. We just don't really feel that it's cost conducive to continue running the business as is if we're going to have to pave that entire lot and do whatever is required, like with the comprehensive development plan. I'd been in touch with the gentleman that does that. It just seems like the process is not for us. So we would just like to wipe it clean and just get it back for sale, and whatever the future owner wants to do, they can do. I know that the city, on the future land use map, they want this area to be industrial. They don't want it to be residential. So hopefully whoever gets that can get that ball rolling.
And just to add that, so our plan is it's up for sale. So we're going to leave the house and possibly rebuild it back into residential. But we were hoping to just tear it down and just turn it all into commercial. At one time, we even inquired about the property beside it. So we were trying to get both lots and add it all as an industrial. But so right now we're leaving it up to the new owners. And if it doesn't sell, then we're going to probably rebuild the house if we can.
Seeking the proper approval if that's allowed. But so I guess what we come to you today, we wanted to explain our side of things, how everything transpired. Like I said, I think several of these zoning ordinance violations are quite similar. With us, with the intention, we have it for sale, with the intention of us putting it back the way that it was, the best that we can do. We would hope that you all would waive the citation fines, $100 each, $600 total. If you feel that those should be upheld, we understand, but then with some of them being similar, we would be willing to pay $300 to meet in the middle and still get the property in compliance and let the new owner continue the work on the property.
Understand you've got the property listed. Have you ceased using it for your towing business?
Yes, we are closing the towing business.
But I guess to make sure if they quit using it for towing business and it's now residential, I guess tell me what happens now they've ceased.
So I visited the site today, and there still are vehicles that are within the fenced-in area. I think there were 2 visible from the roadway, and there's still signage indicating that there is a towing company there. So based on my site visit today, it seems that the use is still operating. Like I'd said previously, they have removed many vehicles from the property that you could see, just from the aerial view, there were many more than just the 2 that were out there today. But if they desire to put it back to its original state, that is certainly an option. The gravel that was there previously, the drive that was there for the home, that was grandfathered in or legal nonconforming, and it could have stayed in that configuration. It was just that in changing the use from residential to industrial, at that point in time, the zoning ordinance requires that those areas then be paved existing plus new. So even the gravel that was added couldn't remain for a residential use either, because today all new areas for that type of use would have to be paved residential or industrial. It's just that the driveway that was there previously could have remained in that configuration as long as it was untouched. So they do have options. I just don't know what the immediate plan is since it's for sale.
Did I say something?
Sure.
Okay, so in regards to what she was talking about with there still being some vehicles there. So we have to abide by the city ordinances, but then there's also state laws that we have to abide by. So with those vehicles, towing them in, the vehicles that are there are obviously not wanting to be claimed by their owners. But we have to send out certified letters. We have to notify them. We have to give them at least 45 days before we can even do anything with the vehicle, like take it to Shelby Recycling or put it up for sale or auction. So our hands are kind of tied in that limbo period and even afterwards, because after that 45 days is up, you still have to go to the clerk's office. You have to apply for a title. That can take weeks to get. And you also have to wait for those certified letters to come back. Those don't come back for months sometimes, because the people aren't picking them up. So yes, we are ceasing operations, and we're working towards we'll remove the signs, we'll get all the vehicles off the lot, but we have to follow the legal process as well,
So we've actually ceased towing prior to today, but some of the vehicles that you may see there were our vehicles, like being parked there. I'm sure you've seen a truck and a dump trailer. I'm not sure what vehicles you've seen there, but most likely they were ours. We're not towing. And one of the reasons that we have closed the towing is because it's very, you don't just meet the person one time, not twice. You don't hear them 3 times, but sometimes you spend an hour on the phone with each customer, explaining how wrong it was and, how bad of a person you are. And then sometimes you have to call the police, and you got 30 more minutes wrapped up in it, and then you got to schedule an appointment for them to meet you at the impound lot. If you don't meet them, if they don't show up, then you got to meet them again. So, it's consistently, you can spend an hour on the phone, and you can spend an hour out in the lot, and another hour, towing the vehicle. So, it's not a very profiting business, especially being regulated. You don't have HVAC being regulated with, how much they can charge. They can come look at your unit and charge you $150 and not do nothing. But you go tow a car, you're set to a certain amount and you can't add any additional. So we decided that we're out of it. So we're willing to do whatever it takes. We can remove all the gravel. We're kind of leaving it up to the new owner, but if the new owner doesn't come up here pretty soon, then we'll just start working on it. I'm finished.
Questions? What would your comment be about out of compliance for 320 days, almost a year?
So the 320 days, I believe, is calculated from the initial complaint. Is that correct? So just from the initial complaint, we were not made aware that a complaint was made. As she said, I think we weren't notified until February. So I don't believe that 320 days is an accurate number of us being aware of the out of compliance status.
So,
You concede it's out of compliance today?
Yes, I do.
Okay, thank you.
Yeah, I already said that. And just like I said, we would like to put this money that we would pay in the citations in order to get this property in compliance. We would like to, remove the gravel, remove the fence. That's not going to be at no cost to us. So in order to get this in compliance, we're going to do it either way. But we would like to, maximize whatever we have to get the property into compliance and to be able to sell it to the new owner.
How fast would you be able to do that?
That's what I was gonna ask, is because it's up for sale, we hate to go in there and remove it, because the gravel's part of the paving process. We hate to go in there and change it up to residential if someone's gonna change it to commercial. So it's kind of if we have to do it right now, we'll do it, that's fine. But if we can have a period of time to try to get it sold so the new owner can go through the process and do what they wanna do with it instead of us dealing with it. The choice is yours, but just asking for a little time. I can have the gravel removed and the fence down in a couple days. But then again, we're sitting with those cars that we're waiting, by law, we can't do anything with. So what are we gonna do with the cars? Which, when I say that, there's 3, 4, something like that.
How much longer do the cars have to sit there?
I don't have that in front of me. It's on my computer. So I know that we've sent out all the letters. We have to send out 2 letters each, one at 10 days and one at 35 days. So I believe I'm just waiting on the return of a couple of those letters. The post office has to send them back to us whenever they don't sign for them. So we're just at the mercy of the Postal Service at this point. Once we get those letters back, I can take all the paperwork to the county clerk. And then, like I said, to get a title issued to us to where we can take it to the junkyard to get those disposed of, because we don't have any plans to sell them. It would probably take, I would say, 4 weeks.
And some of the out-of-state vehicles have to be inspected, so that's added on top of the process.
But to my knowledge, I don't think any of these are out of state.
Another thing, and I don't have the ordinance in front of me, but I think that it requires a fence around the cars. So I think until the cars are gone, the fence probably has to stay by law.
That's a Bowling Green ordinance, yes.
Right.
It has to be secure,
To protect the cars and the property.
even though these people don't want their cars. But
And they're junk cars.
I'll make a motion to table this for the next meeting.
Would 30 days be enough for you guys to start getting everything in motion? Could we see results by the end of these 30 days?
I think that's hopeful. As long as we can get these cars out of there, then like she said, then we can proceed with removing the fence and removing the gravel. So I don't see there being any issue as long as the state doesn't have a holdup in issuing those titles. Because I know sometimes you can get them in a week and sometimes it can take 3 or 4 weeks. Because they have to review all the paperwork. They have to make sure that there's no liens. They have to make sure that the owner was notified correctly. So we're really just at their mercy on, once we get it submitted, how long it's going to take for them. But I mean, at the next meeting, we would definitely have a better update. I could bring whichever vehicles are still there, their paperwork and the status of that.
And I would say go ahead and remove all that gravel and fence and all that, just so you can work towards being compliant. If you can do that, you know, we'll go from there with the status of the cars. So that'll give you 30 days to do so.
So remove the gravel now.
I would recommend it to
I mean, the
work.
gravel will take only a day to remove.
Yeah, we're giving you 30.
Right.
So
But you're not saying, like, remove it now, but
just
you're giving me 30 days
by the next
to
meeting.
do the rest. Okay, gotcha.
Have everything removed, and if you can get the cars removed, then we can be done with it. So
Okay.
I'll make a motion to table it till the next meeting.
Second.
Lapointe, Gonzalez. Roll call.
Holman,
No.
Gonzalez,
Yes.
Harmon,
No.
Lapointe.
Yes.
We have a tie vote at this point in time, so you'll need to reconsider at this point. You have some other motion in that regard, and I understand we have 2 different divergent opinions, but we don't have a majority at this point, so we need to do that.
I'll make the motion. I was going to make them. I'm sure I'll get the votes for it, but I make a motion to uphold the citation and fine the amount of $600. And I'll explain why. This has been going on for nearly a year. And I think you were told fairly early on, just because there's zone industrial, there's still, when you start operating a business, particularly like a towing business, there's lots of other requirements that you have to meet. And it just concerns me, this has been going on nearly a year, and here we still are.
For the same reasons, I second that motion. Roll call.
Holman,
Yes.
Gonzalez,
Yes.
Harmon,
Yes.
Lapointe.
That is an appropriate motion in order, you know.
So,
Thank you.
so we've upheld the fine and citation.
Is that in the cost?
Pardon?
Just add it in the cost of the property, it's fine. Someone's paying for it.
We'll pause for a minute so you can see Madam Clerk about the payment situation.
Okay, so at this point, once we pay the fine, also getting the property in compliance, I mean, you were originally giving us 30 days, so what does that look like?
At this point in time, I think you need to move as all dispatch.
Sorry, what was
I
that?
think you need to move as fast as you can to get it done.
Okay,
We can't move the city and the state, though.
I understand the problem with the fence in the state. It's a dilemma.
Right.
That's why I'm saying, I think.
Hey, we're
try to
done.
move-
I
try
would like
move
to
as
just wipe
fast-
it out today.
Yeah, well, you might call the state.
Oh, no, we do that all the time.
Okay.
It's a dead end. Thank
Okay.
you.
Thank you. Madam Clerk?
Agenda item 2024-28 is for a Bowling Green Police Department parking citation, citation number BG-125855, issued at the property located at 429 10th Avenue East. The respondent is Brian Nash with his attorney Alan Simpson. This case was heard last month by the board, and we're revisiting it to make a decision this afternoon. Officer Jamison McFall is not available this afternoon. The citation fine was $50, and we'll turn it over to Mr. Simpson.
Mr. Chairman, I had talked to both counsel before we started. My understanding is Mr. Simpson still wants to present some evidence because he'd not concluded his at the last proceeding.
Is correct, with one other procedural issue that sort of became pretty apparent as we started the proceeding today, is that Mr. Dearbone's not here. He was here during the original proceeding. Mr. LaPointe was not here at the original proceeding, and he's here now, so he hasn't heard any of the evidence. Mr. Dearbone has, and I know that you were not here, Mr. Broderick, Mr. Davenport was, and I had made a motion to disqualify Mr. Holman because of comments that he made before I even cross-examined the police officer. So what I think I have to always make a record, which I'm going to do, is I'm going to ask that we adjourn this until all of the folks are back, because I would like for Mr. LaPointe to hear all the evidence as well.
Mr. Chairman, we have approved the minutes of the last meeting, which reflect what took place. I will advise you that we follow due process, not absolute procedural due process. There are no rules of evidence. I think we have a board here that can make a decision today. I think what was requested of you to remove yourself to be denied, and I think you should let them proceed with their proof.
Okay, could I swear you in, please, Mr. Simpson?
Sorry?
Could I swear you in?
Oh, sure,
Do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
do.
Thank you.
Planning on testifying, but I would like to, well, I guess I would like a ruling on my request first, and I don't know if, I would ask, you know, like I said,
And I
Mr.
think you can follow my direction. It's my advice to do that, to proceed with the hearing and deny the motion to disqualify you.
Yeah.
That's what we're doing?
Made a record, Mr.
Okay, all right. I would like to call Mr. Nash back up.
Do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God? Thank you.
Mr. Nash, so that at least maybe we can bring Mr. LaPointe up to speed. You were issued a citation for parking right over here in front of the old courthouse, is that correct?
Yes, sir.
And could we bring up the photographs from last time? Sure, I'll just talk louder here. Oh. Here you go. Okay. All right, so that is your truck parked there, correct?
It is.
And looks like that's from body cam. There's a white line painted there. What did the white painting on the line indicate to you?
That it was a space to be parked in. It's actually yellow paint that has been covered by white paint.
Okay. And then, can you switch to the next picture? Yes. All right, now, is that all the pictures you got? All right. Do you have the photographs that we admitted into evidence last time? Yeah, that'd be perfect. While he's pulling that up, Mr. Nash, the parking place, it's not working very well. The parking place that is in front of you where that green car is there anything painted on the ground that the board will see?
I can't remember if the car is in the video, but there is a handicap designation painted on the pavement.
So the universal symbol for handicap parking is painted on that parking space where that green car is?
Yes.
Okay, and then where your truck was there one painted on the ground there?
No.
Okay. Looks like he's got it ready.
Was parked in this space. No handicap marking on the pavement. Here is the sign. Just past the sign is the actual handicap space. This is the space that people park in every day when they have a handicap placard or plate. This is the space that people park in every day where they do not, but where when I was parked there, I was cited for a handicap violation. Here's the back of the sign. Here is the front of the sign indicating that that is the handicap parking space, not this space.
Thank you. Since our hearing last time, have you also found some other places? Have you found some other places downtown? You may have that thing. Have you found some other places downtown where there are handicap signs posted as well?
Total of 4, I believe.
I think there's 2 here, actually.
2 more.
Two
than-
more,
than
and we
what we had
submitted
last
some last time into the record. Do you have those? They were hard copies.
Not scanned in, the board had just had those that were passed.
Were passed out to the board?
Yes.
Do they still have those? Okay, these are 2 different ones. Where is this located?
It's 922 State Street. The address is 922 State Street. I only know it because I used to work at that building.
All right, and then there's the sign that is posted with a sign, and then it's painted on the ground as well, correct?
That is correct. Sign and a painting on the ground.
Then this is also downtown as well, correct?
Yes, this is on College Street. It is in the 800 block of College Street. If everybody's familiar with where Danny's Pizza is, this is directly out the front door of Danny's Pizza. In this case, it is a handicap sign that, again, it's a one-way street, much like 10th Street is. It has the handicap sign at the back of the spot. You have to drive by the sign to pull into the handicap spot, just like you would on 10th Street, but there is no marking on the ground.
So you're saying, looking at this photo, you're saying the handicap spot would be in front?
It's at the, it would be past this, where the sign is at the back of the handicap parking space.
First spot.
That's right, and you would have to drive past the sign in order to park in it. Which is what I believe this
So
condition
this sign
is
is
as well.
actually in this flower bed, is that correct?
That's correct.
Okay, okay.
Done looking at? Yeah, okay. And I know for Mr. LaPointe's sake, we introduced some other photographs. One of them's right up here. If we did a field trip during this hearing, we could go right over here, and then there's one right down here that are marked a lot more clearly than the one right up here. So, Mr. Nash, when you came into the hearing today and parked downtown, did you notice anything different about this parking space up here or anything that drew your attention to it?
The only thing, there's nothing different painted on the pavement. It looks just like it does today. But there was a car that was parked in the same space that I was parked in. It neither had a handicap placard hanging from the mirror nor a handicap plate. I routinely go to the Warren County Courthouse for business, and I've been just looking. Nearly every car that I have observed in that parking space, the same one that I was in, has not had a handicap placard or a handicap plate. It's confusing at best.
Would you explain to the board then why it was you felt like you could park there and why you would never park in a handicap space?
I felt like I could park there because I thought the sign was indicating, as other parking conditions have shown, that it went with the sign. The sign matched what was painted on the pavement. From a personal standpoint, I would not park in a handicap space. I have a daughter who is disabled who qualifies for a handicap placard, and I won't get one because I don't believe she's handicapped enough to be taking up a space for somebody else. It's a pretty personal issue to me, and I just wouldn't do that. Anything else you want to say? I don't know how, what bearing it has on. I am a student of government. I believe government has a responsibility to its citizens to ensure that it's not setting its citizens up for failure. I believe this situation sets citizens up for failure. It is not clear. If in fact that is 2 handicap parking spaces, the citizen has to determine whether or not it is. Does the sign go with one space? Does it go with the other? But it doesn't have anything painted on it. I believe in government, and I believe that this, at worst, misleads people, but it sets people up for failure, and I see it every day in that very same parking condition.
Out of curiosity, what did the police officer say when asked about it?
I'll try to summarize sort of what his testimony was. One of the things that you'll notice is that on the citation itself, it cites the wrong ordinance. That was one of the things we pointed out. The second thing we pointed out is he said to him it was a handicap parking place. And I said, well, how does somebody know that? He goes, well, you just look at the sign. And I think that's Mr. Nash's whole point, is you got the sign that's about halfway up in that parking place. Then you've got the one with the handicap symbol and another ramp up to the front, in front of that sign. And it just stands to reason that the one that's got the thing painted on the ground is the handicap spot. And so that's sort of what the testimony was in a nutshell. And hopefully since I'm under oath, Mr. Holman, I hope I'm not misrepresenting. I think that was generally the testimony.
I think that's right. And then also the city engineer said the sign was the guidepost. You know, the sign, the intent is for the sign to indicate the spot.
Well,
That's her testimony.
Right, that's what they said, but they also said that they had gotten an email from the church, and I did an open records request for that, and there was none. There was no request from the church to do that, so I don't know why that was testified to at the last hearing, because that turned out to be when I heard that, I was like, well, let's see what the email or the letter from the church was. There's not one.
What kind of request?
With all due respect, Ms. Hightower, you weren't here at the last hearing.
She got a request and actually went to Greg Meredith.
It didn't go to
Consensus-
the city then, did it go to the state
Greg Meredith was the public works director.
at the time?
By phone, I'm not sure. It was a request
For what?
for an extra spot for the church. So, and Public Works people are here, they can testify, but the sign is our sign, and that's been a spot, if you read the minutes, since like 2013. The church requested to have an extra spot, and they are the ones that chose the paint rather than the sign. That was her testimony. We don't paint for handicap spots.
They also have a couple above that, I believe, too, right? Two or
Church,
three?
they may.
They do.
They may.
three.
I
And they're
saw
all
them today
painted.
again.
Right.
But they are all painted, correct?
Right, and that may be the church. We don't
Sure,
paint
sure,
at
sure.
all.
I just-
Right,
right.
right. So they requested the spot for the church, and Greg Meredith gave them permission, and they painted the spot instead of doing a sign, probably due to cost for a church.
If the sign is the controlling factor, then the parking place in front of it is not a handicap parking place. I mean, if that's what we have to pick, I guess, but that's why it's confusing at
And
best.
actually, I'm pretty sure she testified that you can do either, but that the preferred method is the sign, but that both control.
Where is that in the book? That she referenced the book, we can't find it in the book.
I don't, Chad and Melanie are here.
So,
Chad's here. He may-
like I said, it's confusing at least.
Can we put back up the picture of the truck actually in the spot and with the sign in the picture as well too?
The next one,
Maybe on the other side?
yeah. That one.
So if somebody can clarify for me without, because this is what's going to be some concerns, Mr. Nash, is the fact is when I'm looking at this, where the sign is, it's almost to the front door of the truck.
Well, if you look at, there's a shadow cast where the front door meets the rear door. That's what troubles me. That's the middle of the truck. And the spot measures 22 feet from stripe to stripe.
Respectfully, that shadow is not meeting where the front door meets the back door.
Well, it's right by
The shadow
the-
is on the front handle of the truck.
Before the handle.
I don't know if that clarification makes a difference, but in the interest of just being as exact as possible.
Yeah, I can't tell if it's front door or the mirror. It's somewhere close to the mirror maybe, if I'm looking at it.
Well, but it also, as you're looking out the front window of the truck, you see the handicap thing painted on the ground in front of you. I mean, you know what, this is a matter of principle. It's poorly marked. He thought he was parked in a non-handicap space. And the officer, I watched the body cam that at first we didn't think existed that exists, and there's some lady who was sitting there on the body cam complaining that her children had had their cars towed from an apartment complex that Mr. Nash's company monitors. So we had sour grapes calling the police, and the police coming down there and putting the thing on there. That's what's on the body cam.
That's a body cam we haven't seen, so.
Right. Well, the city didn't introduce it, but I'm telling you what's on there. It's about 30 seconds of it's redacted. Ms. Hightower's told me why. But you do hear the lady, her face is blurred out, and she says to the officer how long it's been there. And she said, yeah, my children go to school here or something like that. And they've had cars towed where he monitors their parking lot. So she's mad. She calls it in. It's not marked right. I mean, mark it right. If that handicap symbol was painted on the ground, he wouldn't have parked there. If he had parked there, he paid the ticket and moved on. But it wasn't marked properly.
This one right here, the sign is at the midpoint of the parking spot, which is what this one is as well.
Okay? But I'm just telling you,
Is there not
they're
also
marked
a
every
handicap
which
marking?
way.
Well, if they're
There's
marked
also a
every which
Look at the
way,
bottom, Mr. Holman, look at the bottom of that photograph on the ground.
yeah,
There's a big marker on it. That's a handicap parking place unlike the one that Mr. Nash was parked in.
Mr. Doty from Public Works is here, if you all would like to hear from him again regarding the painting, which we don't do, and the signage.
Well, we want to hear from him, but let me ask Mr. Nash a question. So from stripe to stripe, it's 22 feet. This sign is 12 feet from the rear stripe. You think it's pretty safe to assume that a passerby would assume that that's a guy parked in a handicapped stripe?
No.
You
And
don't
the
think,
fact that I see cars parked in it every day, literally every day, Mr. Holman, there are cars that are parked there that do not have handicap placards or handicap plates. That's not just one person's opinion. I see them parked there.
but you heard the city engineer say the sign is the guiding principle.
Yes, and I'm telling you as a citizen, how does a citizen know that? The citizen is supposed to be able to figure out
Well,
if it's the sign or if it's the painting that's on the ground, and the church is allowed to come in and paint on city streets, and we scapegoat churches as a way to justify our position. I mean, is it a city street or is it a church street? And who's responsible for what happens on the street? I don't know how anybody could look at this and not think that it's confusing.
And it's painted white, not blue
Yeah.
or yellow.
I don't see how it's confusing when the sign is in the midpoint of the rear and the front stripe. And the city engineer said the sign is the guiding principle, and she said what we have here is 2 handicap spots. If a passenger in your front seat opens the door, they're going to see a handicap sign. I don't see how that would confuse anyone.
So is the other space a handicap space?
What the city engineer said last
I'm
time.
asking you, as a decider here, do you believe that that space without a sign is a handicap space?
As the city engineer said it was, I would say yes. She said there's 2.
Engineer said the sign is the guide, which is not what that other space has.
I do have a question for the engineer. He's been sworn in. It wasn't.
He has not, yeah.
Would you state your name, please?
Chad Doty.
Uh,
Chad Doty.
Mr. Doty, do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
Do.
Thank you.
Question, I do believe the store, the vintage store right up here on the corner, there is a handicap spot in front of it, and I do believe it is painted blue. I also question if 3 or 4 of the spots out in front of the courthouse have the handicap spot. I do think it's confusing, even if there is a sign there. Why wouldn't you just make them all painted? Whether we paint them or not, why leave that up to us to decide as a citizen? Why are some painted blue? Why are some painted white? Why are some painted on logos and some of them aren't? And how are we supposed to know who painted them on? I mean, I didn't know that the church painted on the handicap signs, so.
What they painted was the typical pavement marking. And what we try to follow is the MUTCD. That's the book that we follow for our signage on that. So what it allows, it says that the sign is that is what notifies the driver, just like anything like a speed limit sign or a no parking. That is what's telling you what the restriction is for the area. The pavement marking is just it's a supplementary. It's either added to tell you it is, or it can help in supplementing additional signs. Because, we can't just litter the sidewalk with all the street signs that we would like to. Sometimes we just got to do the pavement marking. The white paint, what that is, before, if you go way back, there was no parking in that area, had yellow paint. The white paint is to try to cover up the old yellow because the handicap parking space was added.
I meant
And
the
then-
white paint that is actually marking that it is a parking spot.
That is just that's where before it used to have yellow paint, which would tell you that it's a no parking. Because that paint's kind of hard to come up and take off, sometimes what we'll do is we'll paint it white pretty much try to match it same color as the curb to let you know it's not yellow, so you can park there. And then we use signs or the pavement markings to identify what a space is.
I'm just saying, from that spot, if his truck, in this photo, if these cars aren't here, you can actually see the spot I'm talking about probably from this parking spot, and it is painted blue. Just a little confusing to me why one would be painted blue, the other is not.
I can't, so it is not my understanding that's a normal thing that we do with that. And then,
Why do we allow a church to paint the street?
probably that they asked us permission and we allowed them to do it under the director's guidance.
So why was it that when we granted them another spot, we didn't just say paint the street? Why did we put a sign there?
We did the sign.
But why, if we gave them, I don't know how many spots are out there. If we had, let's just
So
say there's 3,
Yeah.
including the one that is painted. You said that they wanted another spot, so we put a sign there saying, here's your other spot. Why didn't we just paint it?
That was the
I know,
city
so-
spot.
Oh, it
with
was
the
already
sign.
there. So
They requested one additional, and our public works director said, of course, and they asked if they
in
could
front?
mark it. The
Gotcha.
one in front, right. So the one with the sign has been there for longer than the one that they marked.
Find it very confusing.
Yeah.
Mr. Doty, you said that in the book that you use, what's it called?
MUTCD.
Is that in the Bowling Green Code of Ordinances or in the Kentucky Revised Statutes?
No, what that is just the national federal guideline for street signs. So that is just a engineering standard that it uses, and
So it's not
Look at-
it's not a law in the city of Bowling Green or in the state of Kentucky?
It is, it's adopted.
Well, hold on, I'm asking the witness,
Okay.
and Ms. Hightower is here as legal counsel, I think, not a witness.
yes, without being able to point, I believe we referenced the MUTCD for guidance on signage and pavement markings.
But just on certain streets, just, so, I mean, that's why I'm trying to understand why some, literally the next street over is painted blue for a handicap spot.
So, again, I can't, I didn't oversee when that one got painted, the blue, so I can't explain to that. The MUTCD says it doesn't require that the curb is painted. What it does say is you want to sign it, and then something that we can do as a supplement to either additional signs or to add to the emphasis on that spot is you can give the standard symbol that everyone recognizes. So that's what I can say on that bit. And then, you know, with a lot of these when these come in, they're requests on existing spots or spots where they weren't. So the signage or things they're trying to get put in as best as they can fit in a spot. So,
In your opinion, is this vehicle parked illegally?
in my opinion, there is a sign that is in between the white lines for a parking space designated for handicap.
Are you familiar with the curb next to both of these spaces?
Yes?
Okay.
What?
We can't see it in this picture, but I do believe that in front of both of these spaces at the front, there is a ramp for handicap accessibility. Am I correct? Both the.
I've not visually inspected to know it exactly.
He discussed
You can
this
tell
at the
from
last meeting.
pictures, But yeah,
Yeah, so the second parking spot in front of where Mr. Nash parked has the ramp with little raised things, so sort of slow down traffic there, I guess, coming onto the ramp. However, the one where he has parked right in front of the sign also has an on-ramp for wheelchair accessibility, correct?
the ramp was installed, I believe. That was the old spot. Also where that's kind of going back into that history of why it used to be a no parking area. That was the original handicap ramp to the courthouse. So it was painted yellow to allow to have parking spaces there. The curb was painted white, so that way it's not being designated as no parking. The sign was changed. I believe if you were able to go back in like old street views, you'd see a no parking sign where the handicap spot's located now.
Right, so all I'm really getting at is there is an on-ramp for both of these spots, correct?
Yes, I would call it the new one that meets up ahead, so in front of the other.
Any other questions for Mr. Doty? No? Thank you, sir.
Any other testimony, but I would like to make a statement if I may.
Of course.
A citizen needs to be aware of how things are marked, and they need to be marked in a clear way. This would be like having a speed limit sign that said 25 and 5 feet behind it said 55, and then you get a ticket. Well, Mr. Nash clearly did not park here thinking that that was a handicap parking space. He did not intend to park in a handicap parking space. I think that's very clear from his testimony. This is not marked clearly. All the city has to do, or if the church wants that parking space, whoever paints all these things, if they go out there and they paint a handicap emblem on the ground, no question about it. But there's not. And one of the questions you just had was the other, I think Mr. Gonzalez called it an on-ramp, the handicap cut into the sidewalk. There's actually one up there, and I think the testimony came in that there's actually the raised red area so that a person who might be blind knows that they're getting ready to walk into the street. This one doesn't have it because it was abandoned as a handicap parking place. If the city wants to claim this back, paint the emblem on the ground, and there will be no confusion about it. But, you know, this is so vague as to which one is what that I think you have to give, sort of like in baseball, you give the tie to the runner. And Mr. Nash is the runner in this case. He's gone through hiring an attorney to come over here, and we fought this bitterly because it's a matter of principle for him, because he would never intentionally park in a handicapped parking space. And so while we may have a difference of opinion about, well, I think the city wanted it to be, but it's not marked clearly, I'm just asking you to say, we get it, Mr. Nash. We realize why you park there, and the city needs to fix it, but I'm going to ask you not to uphold this ticket. And I will tell you that if it is, well, I won't even say that. We will fight this tooth and nail as long as we have to fight it, because it's a matter of principle. And I don't think that under any set of circumstances, Mr. Nash parked in a properly marked handicap parking space. So I would ask you to not uphold this ticket.
I do think that there needs to be some sort of, even if the city's not going to go back through and match every street, you know, to have the same color paint on the road and emblem or whatnot, I think that a street should at least match each spot. So I will make a motion to dismiss both the citation and fine.
Here's we do not have a second to that motion.
So I would like to make the motion to uphold the citation but dismiss the fine of $50.
I'll second that. Gonzalez, Holman, roll call.
Holman,
Yes?
Gonzalez,
Yes.
Harmon,
No.
LaPointe.
No.
We have a tag. Consider another motion.
Yeah, I'll make a motion again, like the one previous, I'll explain it. Mr. Nash, I think, you know, we share a daughter with disabilities. And I firmly believe that you're right. You would never intentionally try to do the parking place you shouldn't. But what bothers me about this one is the fact of how deep that sign is in that parking spot. And like we've heard testimony that from Public Works people, that signage is a major, number one thing they use. The writing on the road is supplemental and secondary to that. But I was, you know, I would look at these pictures, I was concerned, you know, I wouldn't have parked in that spot because of the fact how deep that sign is in that spot. I would have probably thought that sign went with that spot. So based upon that, I'll make the motion to uphold the citation and a fine in the amount of $50.
I'll second it, and I just can't imagine being in Nashville or Lexington and parking in a spot like that. I just can't, just the common sense part of it, you know, midway point in the vehicle, I just can't imagine. So that's my reasoning. Harmon, Holman, roll call, please.
Holman,
Yes.
Gonzalez,
Yes.
Harmon,
Yes.
Lapointe.
No.
We have a tie at this point in impasse, so we don't have a decision.
No,
I'm sorry, I misunderstood.
we
Fine.
upheld the
Okay, excuse
citation
me.
and the fine.
Misheard.
And we'll pause a moment so you can visit Madam Clerk for payment information.
Probably follow the
Guess you file it in district court.
district court, excuse me.
30 days. I'm sorry, I misheard the vote on that. I apologize, gentlemen.
Madam Clerk?
Agenda item 2024-29 is for code compliance. This is a request for authorization to issue a second per-day fine for the case number 2023-5419 for the property located at 1221 West Mead Drive. The owners are Ibarrero and Norma Ramirez. Officer Sandra Duderick will present the case.
This case was presented in front of board in March of 2024 meeting. It was authorized for first per-day fine. The first inspection was done 11/3 of 2023 with the violations of parking in yards, accumulation of rubbish or garbage, accumulation of tires stored outdoors, exterior use or storage of indoor furniture, improper grading and drainage. 3 citations were issued on 12/19/2023, 1/4/2024, and 1/22/2024. Since the last board meeting, I have not been able to get in touch with the property owners. They have not reached out to me. A per-day fine citation was issued on 4/12 of 2024. And it was mailed to the PVA listed owner and address. The property was re-inspected since then on 5/13 and 6/13. It remained in violation. As you can see, they did fix the grading and drainage. However, that is an issue that's brought up to planning and zoning where they added gravel to fix the issue on my end. There's still tires stored. And there's the stagnant water. And on the side of the house, there was accumulation of trash and debris. Go back. Today, there's still tires on the property, rubbish or garbage, junk, scrap metals, scattered garbage, and there's also an inoperable vehicle on the property. There's still tires by the shed. This vehicle with expired tags. Accumulation and scattered garbage. There's a tire by the other shed as well.
Questions?
I'll make a motion to implement a per-day fine in the amount of $100 to run for a period of 60 days or until in compliance.
Second.
Berman, Lapointe, roll call?
Holman,
Yes?
Gonzalez,
Yes.
Harmon,
Yes.
Lapointe.
Yes.
Agenda item 2024-30 is for code compliance. This is a request for authorization to issue a per-day fine citation, case number 2024-0565, for the property located at 1125 Wilson Street. Property owner is Aislinn Holdings LLC. Officer McKenna Tabor will present the case, and I'm understanding their attorney is present and wishes to address the board after.
This case was the result of a proactive inspection that was conducted on January 30th of this year. During the initial inspection, the following violations were observed. There were broken and missing windows, as well as an accumulation of construction and demolition and landscaping debris on the property. On that date, a notice of violation was sent to the PVA listed owner and address. With a reinspection date of February 14th, contact was made with the property owner that day, the property manager that day, about the violations that were observed. There was one window on site that was broken and was completely open, that was rendering the house unsecured and exposed to entry and the elements. Upon making contact with the property manager, it was requested that any open window be boarded and secured within 48 hours. I revisited the property on February 2nd to find that the property had been boarded, and at the time that the windows had been secured. On February 2nd, February 16th, February 23rd, and March 21st, the property was inspected and remained in violation. During this time, our office was in communication with the property owner via the city attorney, and the property owner was made aware of the property and violations in question. On March 27th, the property was inspected and remained in violation. A citation was issued and posted on the property, as well as sent by first class and certified mail to the PVA listed owner. The compliance inspection date listed on that citation was April the 8th, 2024. On April the 9th, the property was inspected and remained in violation. There had been no correspondence to our office regarding correcting the violations from the property owner or their management. A citation was issued and posted on the property, as well as sent by first class and certified mail to the PVA listed owner. The compliance date listed on that citation was April 19th of 2024. And as you can see in those pictures, the property still remained in violation on March 27th. On April 22nd, the property was inspected and remained in violation. A third citation was issued and posted on the property, as well as sent by first class and certified mail to the PVA listed owner. The compliance inspection date listed on that citation was May the 2nd, 2024. The following violations were added that day for peeling, flaking, and chipping paint, as you can see in those photos, as well as scattered garbage. As of today, all possible attempts have been exhausted to work with the property owner to bring the property into compliance. The case has been open for 146 days, as well as the duty of maintenance of private property. It's rendered an attractive nuisance and has not had utilities since June 14th of 2021. And as you can see from photos from today, the windows are still boarded up, it's still missing the paint, and the garbage is still scattered throughout the property.
Questions? Hang on just a second. Do we have any questions? No? Okay, Mr. Moore, would you approach?
Mr. Holman, if I might make a comment before the gentleman speaks. There is a second case owned by the same owner of another property that's going to come in front of the board. I think it's 2 agenda items from now. So just to keep that in mind as he's speaking, is that I assume that he's going to reference both of them, but of course you'll have to make a motion one at a time on each one.
May we swear you in, please? Do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
Hampton Moore, I do.
Thank you.
So I'm here on behalf of the property owner, Aislinn Holdings, and present with me is Jamie Dewberry, who is the property manager. I think there has been some confusion between the property owner and the code enforcement officials on what the property owner needs to do to become compliant. After speaking with him and the property manager, they feel that they are attempting to make the requests that are made to make it compliant, but apparently what they've done is not up to what the board would like. I would ask for the court to consider, not the court, the board to consider retabling it for 30 days out, and if it's not so inclined, and the alternative to consider, if they do issue the 30-day or the 60-day per day fine, to at least not allow that to run until the next month's meeting, to give time to at least figure out what the issues are and see what we could do to get it compliant. That's all I have. Thank you.
Mr. Moore, I've got one question for you, I guess, if you can. You didn't really specify what the confusion was between everybody, but the way I understand it, and correct me if I'm wrong, there's already been 3 citations on this property. None of them ever appealed. And it's been 146 days since this started until, I guess, close to where we are today. But there's been 3 citations, and there's apparently not much communication with staff or appeals of those and anything else. Is there a reason why they ignored all the citations?
So, in speaking with the property owner and in review of the statute in question, I think that a lot of the times the mail of where notices are going, they'll sit, if they sit for a week, 7, 8 days, your ability to appeal is already gone. So I do know the property owner is aware of his compliance issues. And I know efforts are made through the property owner and his management to address those, but he does, he owns a few properties, and I think he attempts to address all the issues that are brought to him.
Well, let us point out, you correct me if I'm wrong, but what we would be doing is approving our ability to put forth a per day fine. Then it's the discretion of enforcement when to enforce it. So it wouldn't necessarily begin tomorrow. Is that right?
Correct. So what the board, or what staff is requesting of the board, is authorization to issue that next citation. So in general practice, staff is able to issue a citation upon observing a violation without notice of violation or after notice of violation, up to a total of 3 citations. After 3 citations have been issued on any one case, our policy is to come before the board and request issuing the next citation, which then we request is $100 per day for a maximum of 60 days. If the board were to approve that, then tomorrow or the following day, the code board clerk sends out a letter to the property owner informing them that that was authorized and allowing them 10 days to come into compliance. After that 10-day period, then, the citation can be issued. So we're still looking at another 10, 11, 12 days before that citation would even be issued. If in that meantime there's correspondence, cooperation, communication, and improvement on the property, then generally the officer is going to continue working with the property owner, because that's our goal. That's the whole reason why we're bringing this before the board. If the board were to table this or decide not to issue that or authorize the issuance of that citation, then that hinders our enforcement another 30 days, which then is another 10 or 12 days after that if you were to approve it at the July hearing, and now we're 40-some further days down. So the request is that we get authorization for that, and then we use our discretion in enforcement and allow them that period of time. And if that takes another 30 days while they continue working on it, so be it, as long as there's progress. But it just puts us behind the ball if we then have to come back before the board with these properties.
Thank you for that.
I'll make a motion to implement a per day fine in the amount of $100 to run for a period of 60 days or until compliant.
Second.
Point. Gonzalez, roll call.
Bowman,
Yes.
Gonzalez.
Yes.
Harmon.
Yes.
Lapointe.
Yes.
If I just make clear, that was just for 1125 Wilson, correct?
Agenda item 2024-31 is for code compliance. This is a request for authorization to issue a per-day fine citation, case number 2023-5419, for the property located at 922 Magnolia. The owner is Melanie Grace Smith. Officer Sonia Duderick will present the case.
922 Magnolia Street requests for authorization to issue a per-day fine citation. This was a result of proactive inspection on 1/10 of 2024. During the initial inspection, the following violations were observed: accumulation of construction material and improper boarded windows. NOV was sent to the PVA listed owner and an address with a reinspection date of 2/12/24. On 125, I left a door tag at 1318 State Street for Ernest Smith. On 2/13, I re-inspected the property which remained in violation, and 2 days later, I attempted to make a contact at 1318 State Street to speak with someone without any success. On 2/26/24, Andrew Manny called, advised he was having issues with contractors since his mother passed away and was trying to figure out where she has ordered the windows to be replaced. The property has been in violation since the tornado, December tornado. On 3/8 and 3/21, the property was re-inspected and remained in violation. On 3/21, Andrew called again, advised he'll be getting windows measured so he can order them. Since then, multiple attempts were made to make contact with him without any success, and property still remained in violation. On 5/1, the property was inspected. A first citation was issued with a compliance date of 5/13 of 2024. If you can see on first citation, the top 2 windows are still boarded up. The back side of the house window is boarded up, and the garage door is still there. I have even asked Andrew if he can just pick that up and just haul it off, so it's not there. So nothing on this property since the first contact with anyone was done. A second citation was issued on 5/14 with a compliance date of 5/24. The properties stayed the same. There's no improvements. As you can see, the first and second citation are now on the door. The window's still boarded up. The third citation was issued on 6/3/24 with a compliance date of 6/13/24. Now there are 3 citations on the front door, and property remained in violation with no improvements at all, no contacts from anyone. As of today, there's accumulation of construction material, boarded windows, fascia and gutters and gable are in disrepair. The property has been in violation for 167 days without any attempt to get it in compliance.
Thank you. Any questions or comments? Entertain a motion.
I'll make a motion to implement a per-day fine in the amount of $100 to run for a period of 60 days or until in compliance.
Second.
Harmon, Gonzalez. Roll call.
Holman.
Yes.
Gonzalez.
Yes.
Harmon.
Yes.
Lapointe.
Abstain.
Agenda item 2024-32 is for code compliance. This is a request for authorization to issue a per-day fine citation for case number 2024-312. Property is located at 1129 Wilson Street. Property owner is Aislinn Holdings LLC, and Officer McKenna Table will present the case.
This case was the result of a proactive inspection that was conducted on January 22nd. During the initial inspection, the following violations were observed for an unsecured accessory structure, boarded and missing doors. There were roof, drains, gutters that were in disrepair at that time, as well as an accumulation of construction and demolition and landscaping debris. An NOV was sent to the PVA listed owner and address on that date with the compliance inspection date of February 1st, 2024. On February 2nd, the property was inspected and remained in violation. On February 6th, February 16th, February 23rd, the property was inspected and remained in violation. During this time, our office and property owner were in correspondence with the city attorney regarding the property and the violations on the property. On March 27th, the property was inspected and remained in violation. A citation was issued and posted on the property, as well as sent by first class and certified mail to the PVA listed owner. The compliance inspection date listed on the citation was April the 8th, and the following violations were added. The residence was vacant and has not had utilities since August 17, 2023, per BGMU. There is an accessory structure that has a door on the side that is damaged and has a large opening in the door, rendering the building vulnerable to the elements and poses as an attractive nuisance, as well as the fence being damaged. There is missing and damaged siding, as well as indoor furniture at an outdoor location. On April the 9th, the property was inspected and remained in violation. There had been no correspondence from the property owner to our office. A citation was issued and posted on the property, as well as sent by first class and certified mail to the PVA listed owner. The compliance inspection date listed on that citation was April 19th, 2024. On April 22nd, 2024, the property was inspected and remained in violation. Another citation was issued and posted on the property, as well as sent by first class and certified mail to the PVA listed owner. The compliance inspection date listed on that citation was May the 2nd, 2024. And as you can see, there's the citation posted, and there's been no change to the property in any of this time, as well as no correspondence from anybody affiliated with the property. As of today, I went back to the property, and it remains in violation. That accessory structure to the side is still insecure, and there's this large opening in the door. There was a lock on the door, but it looks like it's been broken, as well as all the doors still being boarded up, the windows still being boarded up, as well as there's the large gutter that's been moved from one side of the house to the other side of the house that appears to have fallen off the house. But all possible attempts have been exhausted to work with the property owner to bring the property into compliance. The case has been open for 154 days.
Thank you.
Still under oath?
Yes, sir.
The comments that I made on 1125 Wilson Street would also be applicable to 1129 Wilson Street, and I have nothing further to add.
Make a motion to implement a per-day fine in the amount of $100 to run for a period of 60 days or until compliant.
I'll second.
LaPointe, Harmon, roll call, please.
Holman,
Yes?
Gonzalez,
Yes.
Harmon,
Yes.
LaPointe.
Yes.
I believe that's our last case. Our next hearing will be on Tuesday, excuse me. Oh, I'm sorry. Do you? Okay. Well, we're glad to have you, especially with that shirt on. Next hearing date will be Tuesday, July 23rd. If we could get a motion to adjourn.
Motion.
I second that.
LaPointe, Harmon, roll call.
Holman,
Yes?
Gonzalez,
Yes.
Harmon.
Yes.
LaPointe.
Yes.
Meeting adjourned.